Today is 5 common legal misconceptions in contract law. So I'm just gonna dive through it, but actually may isa pa, may bonus advice towards the end. So may bonus tayo today. So 5 plus 1. So I'm gonna dive straight through it. Number one misconception is pag signed yung kontrata, automatically valid. Actually, not necessarily. Dito sa UK, it's subject to what we call a test of reasonableness. And mostly that would apply to exclusion ng liability. Yung mga nag-attempt na exclude yung liability nila sa contract. Additional point is you cannot exclude liability under contract for personal injury at death. Even if you put it in there, tatanggalin ng korte yan. But that doesn't mean don't read your contract, but just take note na it's still subject to a test of reasonableness. Number 2, misconception is you can insert heavy obligations dun sa fine print. Lagay mo lang ng Arial font number 4, okay na. Again, that's a big misconception. Please don't do that. It's subject to what we call a test of incorporation or a test of notice. Nabigyan ba ng tamang notice yung kabilang partido? Nabigyan ba ng tamang enough information yung kabilang partido to understand kung ano yung expectation at obligation niya sa contract? So if you're gonna try to put it dun sa footnote o kaya dun sa likod, napakaliit, di naman mabasa, ay pwedeng sabihin ng korte ay hindi mo nabigyan ng notice. So possibly hindi yan napapasok. So the practical advice is wag tayong tuso. We have to lay the cards on the table. If there is a heavy obligation, lagay mo, i-bold mo, ilagyan mo ng mas malaking font letters. That's a practical advice actually. And I do that myself. Big bold letters nakalagay sa box, the heavier the obligation. Para later on, sasabihin sa akin na hindi ko nabasa yan. Andun na, nasa mukha mo na yung obligasyon na yon. You can't possibly say na hindi ka nabigyan ng notice. Number 3, misconception number 3, ay, nakita ko tong contract na to, ginamit ng malaking kumpanya. It works for them, so it must work for us. Not necessarily again. Clarification number 3 is contracts, it has to be checked, it has to be tawag namin strength tested sa business process mo. Kung paano mo ba dinideliver yung product mo? Ano ba yung mga risk sa business processes mo? So be very careful with copy-paste ng mga kontrata na nakita sa internet o nakita mo sa ibang kumpanya. It's not necessarily applicable, even the same industry, even the same companies, to big companies, medium to small size companies, they operate differently. So just be very careful of that. Misconception number 3, this one, it's very, very, it's a unique feature of English law. A lot of people think na pag nag-breach ng kabilang partido yung kontrata, is that they can claim, in addition dun sa financial loss, they can claim for, ay, na-stress ako. Ay, na-disappoint ako sa iyo. Kaibigan kita na-disappoint, na-injure yung feelings ko. I'm very stressed about all of this, so I'm gonna add that to the claim. From what I know, American law is able to do that, but one unique feature of English law is that they make it very hard to do that. Unless yung kontrata nyo is a contract for enjoyment, like holiday. Pero kung the classic example of this, according actually sa law, case study to, I think it's a swimming pool, building contract. Sabi, ito yung exact na kontrata, ito yung exact na specifications pala na paki-build mo. And he didn't build that. Hindi niya dineliver yung napag-usapan. And the other part was saying, well, hindi ko na-enjoy yung I was very stressed, I was very anxious, and I want to claim for that. So yung limitation ng English law, you can't easily claim for that. And ang dami kong kliyente na gustong mag-add. So pagkatapos namin itali yung losses, gusto nilang ilagay, oy, na-stress ako, pwedeng palagay yung stress ko dyan, i-add natin. Although, I probably note it just as an acknowledgement ng impact dun sa kabilang tao is quite important. But yung in terms of quantifying that, it's very hard, lalo na kung hindi contract for enjoyment yon, yung pinasukan nyo. And number five, um, it's not as common. I think people do know this, but just for the avoidance of any doubt, sometimes people still think that may forever sa contract na when you sue someone, that when somebody breaches a contract that you have forever to sue them. Wala pong forever dito. You have 6 years. You have 6 years to sue someone for a breach of contract. After that, you can't claim. So and don't, the practical advice is don't leave it until the last minute at baka hindi kayo makaklaim ng interest. So um, act promptly. Make sure you have all the evidence, yung paper trail nyo, and don't leave it after 6 years. And then bonus advice is I'm going to be a little bit inspired by Kim Chu's viral how do we call it, principle. So some people would say, well, classic question is, Donna, can we get out of the contract? Pwede bang lumabas? Pwede bang lumabas sa kontrata? So, pag nag-comply ka sa obligasyon mo, yung kabila, hindi nag-comply, at present mo na maayos yung law at yung negotiations mo, the practicalities, pwede kang lumabas. Pwede kang lumabas. So, that's trying to hopefully be inspired a little bit by this. Pwede ka lumabas, nag-comply ka, at yes, pwede ka lumabas in the end. So